I'll now call 126-550 in the matter of the wrongful conviction of Jason Mashaney.
Good morning. May it please the court. Solicitor General Anthony Powell, appearing on behalf of the state of Kansas, the appellant in this case. May I reserve 3 minutes for a rebuttal?
3 minutes is reserved.
Thank you very much. The state is asking this court to reverse the district court's judgment on behalf of Mr. Mashaney. The district court granted a certificate of innocence and awarded damages in the amount of $414,000 to Mr. Mashaney. For the benefit of the students that are here, I'll give a brief kind of history of this case because it is long running.
You even had a piece of this case at one point.
I did. And I will tell the court, I did visit with my subordinates about that. Since this technically is a different matter, I was a district judge in the 1507 in this case and was reversed by the Court of Appeals. So that's my small bit in addition to today. But Mr. Mashaney was charged way back in 2003 with a single count of aggravated criminal sodomy, 1 count of aggravated indecent liberties with a child for acts committed against his 5-year-old daughter. The charges were later amended to add an alternative count of aggravated indecent liberties. The first trial ended in a mistrial. The case was retried again, and Mr. Mashaney was convicted in July of 2004 of aggravated criminal sodomy, a severity level 2 person felony, and aggravated indecent liberties, a severity level 3 person felony. Prior to sentencing, Mr. Mashaney raised claims of ineffective assistance of counsel. After a hearing by the trial court, the court rejected those arguments. He went up on direct appeal and his convictions and sentence were affirmed. He then filed a 1507 in the district court, which when I was district judge, I denied on appeal. The Court of Appeals saw it differently, felt that he had raised significant claims of ineffective assistance of counsel that warranted an evidentiary hearing. It went back to the Sedgwick County District Court, and the trial court, after an evidentiary hearing, found Mr. Mashaney's, both his trial counsel and his appellate counsel, ineffective and ordered a new trial. It was at that point in 2011 now, where time has gone by, and the state and Mr. Mashaney reached a plea agreement. And that plea agreement provided for Mr. Mashaney to enter a guilty plea pursuant to North Carolina versus Alford to 2 counts of attempted aggravated battery, each severity level 6 person felonies, and 1 count of aggravated endangering a child, a severity level 9 person felony. Mr. Mashaney was given a downward durational departure and was sentenced to 72 months in prison on February 24th, 2012. Because of the time that he spent in prison under his prior conviction, he in essence had in excess of jail credit, and so he basically served no time for his new convictions. Shortly thereafter, Mr. Mashaney sued the Board of Indigent Defense Services as well as his 2 lawyers who had represented him. The district court dismissed his claims, finding 1, that bids could not be sued, and 2, the court found that Mr. Mashaney couldn't prove his actual innocence due to the fact that he entered into an Alford plea. The Court of Appeals affirmed that, but this court granted review, and in August of 2015, while it affirmed and agreed with the Court of Appeals that bids couldn't be sued, it disagreed with the Court of Appeals and the district court's view that to prove legal malpractice, Mr. Mashaney had to show actual innocence. And so the case was remanded back to the district court. It was then that the lawyers settled with Mr. Mashaney on those claims for roughly $91,000. Subsequent to that, in 2018, the legislature passed what we now call the wrongful conviction statute, which allows those wrongfully convicted of felony crimes to seek redress in the courts for their wrongful conviction, those who have been convicted of a felony and served time in prison. Mr. Mashaney, in early of 2020, brought this present action for wrongful conviction against the state. There was a trial before Judge Comer, and Judge Comer agreed with Mr. Mashaney and found and granted him a certificate of innocence and awarded him the damages that I've indicated. It's the state's view that the district court erred here and that the district court should be reversed and the award vacated. And principally, it's the state's view that this case is controlled by the Doles case. And unfortunately, when we briefed this case, we didn't have the benefit of the several opinions that this court has issued over the past year, which have really clarified the law here. But it's the state's view that this case is really controlled by Doles. And in Mr. Mashaney's case, Doles, we think, teaches us that he had to prove two things. One, actual innocence, and two, that the dismissal of his charges were the result of that actual innocence. And that's where I think his case falls down.
Let me ask you about Sims, which preceded Doles, but interpreted a different part of the wrongful conviction scheme. And in Sims, the district court made a finding of these charges being effectively dismissed.
Right.
And it seems to me that's not aligned with the way we've interpreted the statute from Sims, which also honestly kind of is, to me, is a legal question where I'm more comfortable than when you get into Doles and what caused what and all that. So why is Sims not controlling?
Well, let me make 2 points about that. First, we disagree with the district court that there was a dismissal here. I'm just saying for the purposes of the elements, Mr. Mashaney can't even go to the next step, which shows that even if you assume there was a dismissal in this case, he can't show that that dismissal was caused by his innocence. The fact is that the case was sent back for retrial and a plea bargain was entered into because of the ineffective assistance of counsel claim. And so that was the basis for the amendment of the charges. I think the issue here was we've got a witness who was a young child when she first testified. They're clearly having problems. We couldn't secure her presence to testify in this particular case. So the record isn't entirely clear as to those reasons, but I think the record shows sufficiently that there is no showing, at least I think I can confidently say in the record, that the Sedgwick County District Attorney's Office made an agreement because of his innocence. Clearly, Mr. Mashaney entered into a guilty plea pursuant to Alford, and I think that's prohibits a finding of an actual innocence. But with regard to the dismissal, Justice Biles, I think you're right. Because he wasn't absolved of his criminal liability, and because the criminal proceedings didn't end at the time of the original remand, he can't say that the charges were dismissed at all. They weren't in fact dismissed.
Did the amended charges arise from the same set of facts or transaction as the original charges?
Yes. But I want to be clear, and I think I should be candid with the court. I spent a lot of time looking at that issue because the charges that he pled to obviously are different from the charges that he is originally charged and were vacated. The initial charges, of course, are sex crimes, while the ones that he pled guilty to are, in essence, attempted aggravated battery. And so in doing the research, I don't think would be accurate for me to say that they're lesser included offenses of the originals, but what I would say, I guess, the common nucleus of operative facts, for lack of a better term, are you have a touching, an unwanted touching, and harm. And so from that standpoint, I think it's the same. It's not something where, okay, he had his convictions for sex crimes vacated, and the state entered into a plea agreement agreement in which he then pled to jaywalking or something like that. I mean, these facts, we're still looking at his conduct from that time period back in September of 2003, and that's what those charges are essentially for. And so,
Procedurally speaking, was there, I assume there had to have been an amended complaint filed,
yes,
and did that happen in conjunction with the plea agreement?
yes, it was filed actually after he entered his plea. The
So
the transcript of the plea talks about what the facts are, and it's basically
that's odd. So he pled to
that happened.
something he hadn't been charged with?
Well, it just happens I mean, I took a lot of pleas where they've got it right there. We do the record.
In other words, it's
gets
all
filed.
simultaneous.
But he read basically the elements in the record.
The amended complaint is essentially that's the quid pro quo of the plea deal, essentially.
Yes. I mean, Mr. Mashaney testified at the hearing, at the trial, was that his interest was he wanted to not have to spend any more time in jail. He didn't want to admit to any sex crimes. And so the state, in order to, get the plea, basically, amended the complaint to reflect his actions, but take out those particular elements that Mr. Mashaney didn't want and limit his sentence to basically roughly to time served.
It is kind of odd. We have recanted testimony that absolves Mr. Mashaney of the acts that he was accused of and convicted of.
Well, we don't have actually recanted testimony. I mean, we have the father and mother and Mr. Mashaney claiming that the victim has recanted, but we actually don't have the benefit of her actually recanting.
Okay.
I think that's important. So I think that's an important difference. And
Yeah, I appreciate that.
I mean,
but let's say we did have recanted testimony,
Okay.
and we vote that happens, that people are convicted and later absolved of the consequence of what occurred because for whatever reason there's recanted testimony and the evidence is not truthful or made up or pressured, whatever happens in those situations. What is the pathway or is there a pathway when that circumstance occurs to getting relief under the statute?
well,
Or there might not
I'm
be.
sure the recantation is the operative word here. It seems to me that the two key elements are either actual dismissal, but this court has said in Sims that the criminal case goes away, or there's an acquittal. And this court has addressed a number of cases where it's sort of in between, and this is another one of those in between cases.
I agree.
This court has never awarded anyone or upheld any award to anyone when you have something that's in between like we have here. This is very similar factually to what you had in the Spangler case. The Spangler case where he's tried for second-degree reckless murder, a new trial is ordered, and he's then convicted of the lesser included offense of manslaughter. And he's given a sentence that's less than the time he's already served. He made a claim under the statute, and this court said, well, you can't prove that your actions didn't cause your conviction and incarceration. The same is true here.
And
he just did it through a plea, but it's the same thing.
a little bit to that point, in our recent decision in Doltz, as you know, the court emphasized the causal factor that is present in the statute.
Yes.
So my question is there anything in the record? Did the district court make any findings about causation in the record?
No, that's the problem. He didn't. It's almost like he skipped over that element. I think that's a fatal to the court's order in this case. I see that my time
From
is.
that, I think you agree that all factors A through D have to be established by.
Yes. Absolutely. Absolutely. See no more questions. I'll sit down. Thank you.
May it please the court. My name is Laurel Driscoll. I'm appearing for the appealee, Mr. Mashaney, in this matter. And I want to jump in right into one thing that I want to clarify that was stated by opposing counsel in this matter. If the court looks at the record from the civil trial that was held on the wrongful conviction matter, it's very clear that the record actually does not provide any evidence, any argument whatsoever by the state that there was a reason that the state chose to enter an Alford plea instead of retrying Mr. Mashaney. I think the state, my understanding of his statement and his argument was that the state chose to go forward with the Alford plea instead of retrying because there were issues about getting witnesses or other evidence. And that's absolutely not true. If the court looks at the record from the civil trial, there was no evidence presented by the state whatsoever as to the reason why the state chose to enter an Alford plea.
Isn't that fatal to your client's claim under our recent decision in Doltz?
It's not, because there's some things that this court should take into consideration with that. First of all, it was an Alford plea, so he maintained his innocence with entering that plea. Second of all, the Alford plea, as was mentioned, those charges were completely different from the original charges that Mr. Mashaney was convicted of, both in substance. These were non-sex charges as opposed to what he was convicted of, which were sex charges, and also in severity. They were much lower in severity. The other thing that this court should take in mind with this Alford plea is essentially the state came to Mr. Mashaney offering him time served.
But and I understand all that, but you started out suggesting that the record is absolutely devoid of any evidence of causation. And highly summarized, I think the Doltz stands for the proposition that the statute requires a showing that one of three things happened caused by actual innocence. Either a reversal, a dismissal of the charges, or an innocent verdict. Not guilty verdict, I should say.
And our argument is that, like the district court found, Mr. Mashaney's original charges were effectively dismissed.
Sure, and if we grant you that, I just want to hear your response to, maybe you disagree with my characterization of Doltz or just think it's wrong, but I want you to talk about that causal factor. Like, even if the district court did find actual innocence, isn't there a requirement that there's a finding of causation?
And I think that Mr. Mashaney has been able to show that through what was presented during the civil trial in this case. One of the big things that Mr. Mashaney showed during the civil case is that there was actually a report by a child neurologist named Dr. Richard Gilmartin, who had a report that basically, it was very favorable to Mr. Mashaney in his defense, basically stated that the child had a skin infection, and basically came to the conclusion that in his 40 years of experience, he found it very improbable and unlikely that this happened.
But that all goes to actual innocence, right?
Right. And so this report, though, was never submitted as part of Mr. Mashaney's trial in the criminal charges. And the only thing that was presented by the state during the trial, if the court looks through that record, is the testimony from the victim. That was the only thing that was presented by the state. Mr. Mashaney was convicted. Later on appeal, when Mr. Mashaney appealed the matter and the court found that he had ineffective assistance of counsel for that matter, one of the reasons that the court found that he had ineffective assistance of counsel was that there was actually this report out there that stated that what he was alleged to have done was improbable, probable, or unlikely to have happened, but it was never submitted to the jury. And if it would have been submitted to the jury likely would have found him to not be guilty. And so that was part of the reason why the court found his trial counsel to have been ineffective, is because that was never presented. It was then that report for the first time came to light through this appeal. Mr. Mashaney's conviction was then reversed and remanded back to the district court. And the state then after knowing that report was now out there, having not seen it before, the state then decided to effectively dismiss Mr. Mashaney's charges and allow him to enter this Alford plea that was to different charges, less severe charges, allowed him to maintain his innocence, and gave him time served, which I think it's important.
It allows them to make, Alford pleas are kind of a hybrid type of plea. I took lots of those when I was at district court, but the ultimate conclusion and the finding and the warning and the caveat that's given to someone entering an Alford plea is it results in a conviction based on the facts that are presented to the court. I mean, it isn't a finding of innocence. It might allow someone who takes an Alford plea to claim innocence, but it's not a finding of innocence. Correct? I mean,
But Mr. Mashaney maintained his innocence through that. And I think it's important for the court too to keep in mind that by entering that Alford plea, he was released from prison that day. He walked out of prison that day. He didn't have to do another day of prison. If he would have said,
not because he was innocent, because he pled to charges in which encompassed the time served that he'd already done in incarceration.
But these charges were also,
And they're based on the underlying facts of the original claim.
But they're non-sex charges. They're of a much lower severity. And I think one thing to keep in mind too is I don't think we can fault Mr. Mashaney for deciding I'm going to take this Alford plea and walk out of prison today.
Makes perfect sense.
As opposed to I'm going to go back to prison and await another trial, another year, 2
Perfect
3
sense,
years.
but that doesn't necessarily equate to him being found in or a certificate of innocence. I don't think you can base that.
Well, I think what the court needs to keep in mind is we have both this report that came out and it didn't come to light at all until on the appeal. This court in the Doltz matter, it brought up the issue of having DNA tests, for example, if you have a person who's convicted of, for example, murder, they're on death row or life in prison, and it comes out that there's this DNA test that then shows that they had the wrong person. It wasn't this person who did it. And then they're released from prison and considered innocent. I think the court recognized, or what the court was trying to show, that was what its intent was with this matter. This is synonymous with that because you have a scientific report that wasn't provided in the trial on the criminal matters. It wasn't provided. It was favorable to Mr. Mashaney. And then you later down the road have this report come out saying that it's essentially impossible for what Mr. Mashaney was alleged to have done to have happened. And so it's very similar with later down the road getting that DNA test, it showing that they had the wrong person.
So if I can understand I think I'm following you, but let me just make sure. I'm going back to causation, the causation question, whether or not, the dismissal was as a result of innocence. And you're suggesting that when you put on evidence that there was newly uncovered evidence of innocence, and then subsequently the prosecutor dismisses charges, it's reasonable to infer that the causation from those two sets of facts.
Exactly. Because I think the problem that you're going to have is you're never going to have a prosecutor go up to a defendant and say, I'm dismissing your charges because I think you're innocent. You're just not going to have that.
That actually does happen. I mean, that's what's in the legislative record of prosecutors saying, wow, we convicted the wrong person. And it strikes me that your argument here is that these prosecutors obtained a guilty verdict that they knew they had the wrong person and they still obtained a guilty verdict. Is that what you're saying?
Well, they didn't retry him. If they really thought that he
but
would.
they obtained a guilty verdict. That's the implication of your argument. And I'm just trying to sort of understand it better.
My argument is that they got this new information.
And your argument is this new information is like a DNA test. It's
correct.
It irrefutably, scientifically demonstrates that your client did nothing wrong.
Well, it shows that what he was accused to have done was unlikely or impossible to have actually have happened.
Does that include the amended charges?
Well, and again, it's going back to that my client, he was very adamant that he was not going to enter a regular guilty plea, and he was not going to enter a guilty plea
Okay.
to the original.
And maybe it's hard for you to talk about, and I understand you don't want to speak in any way that could be construed against your client, but just hypothetically, like, are you suggesting that, I mean, there's a difference between somebody else did it and what you said I did is wrong. I actually did something less bad. Do you see the difference between, and what I'm asking is, with respect to this new evidence, is it, you characterized it as somebody else did it evidence.
Mhm.
But what actually happened is I did something less bad.
Well, I think you can characterize it either way. You can characterize it as someone else did it or I didn't do it. If the person's
Okay.
DNA wasn't at the crime scene, they didn't do it. And I think that's
So just help me understand the evidence here, your position is your client actually did nothing.
right.
And that this evidence definitively proves that.
Right. And if that would have been shown at his original trial, just like if a DNA test would have been shown saying this person wasn't even at the crime scene, that he likely would have never gotten
So
convicted.
the prosecutors here knew that he was innocent and obtained a guilty verdict anyway.
Well, I mean, I think you can read from the circumstances, you can read everything together and assume that's what their thought process was, that they were not going to be successful on a retrial due to this new evidence.
May I interrupt? I mean, that is one interpretation. But if, you know, what you're asking us to do is jump into the minds of the district attorney, just like you said, you know, to speculate, or it's a reasonable inference that they didn't retry him because he was, you know, not guilty of the charges. And I know it puts it in a really bad situation when, you're not guilty of the actual charges, and then they give you a get out of jail free card and ask you to plea to lesser, I did something less bad. But when we're talking about the wrongful conviction statute and we're talking about causation, and I do want to say that your client is the one that bears the burden, right? To prove this causation. How did he prove causation when, I mean, I could see proving causation, they told me that, or, but it doesn't seem like the prosecutor, they didn't dismiss the charges, and they, I mean, even if you construed that they didn't dismiss, that they dismissed those charges and amended the complaint, I'm just not getting this whole, meeting the causation.
Well, going back to my point about, I mean, I think it's going to be very unlikely that you're going to have a prosecutor who's going to flat out say, I think this person's innocent.
This is speculation.
And even further on that, especially if we have a wrongful conviction statute that says the only way that a person can seek relief through this statute is if the prosecutor does that, then
right. But what you're imputing to the prosecutor is bad faith. And I'm not sure that I can, well, I know that I can't just say, oh, you know what? So prosecutors are not neutral. They're not trying to achieve justice. All they're trying to do is get the guy and make sure he doesn't get any wrongful conviction money. Are you saying they were looking ahead to that when they were trying to resolve this? Well, let's just make sure that he doesn't get any wrongful conviction. I mean, you're giving a bad motive to the prosecutors.
Well, I think it's just a dangerous slope to be created. And I think looking at the circumstances in this case, I mean, like I've said, you have this report that comes out that essentially says.
But I understand, but the thing is that we don't create a situation. We didn't write the statute. The legislature has the authority to write the statute. They had tons of hearings, they had testimony. And so we are just required to follow the what the legislature, what the law is. And so whether it creates, we're not creating anything. We're just saying, as we did in Doles and as we did in Sims before that, here's what the legislature is saying. This is when you get the money for a wrongful conviction.
And my argument is looking at this statute, I think this is exactly the type of case that the legislature created this statute for. He's someone who, like I've pointed out, he has this report that was never submitted, and once it was, then that's when his case.
How is this similar to Lamont McIntyre? Okay, where, okay, he didn't do it. The prosecutor dismissed the charges against him. Front page of the Kansas City Star, this guy's innocent.
Well, and the other thing
The reason we're dismissing it is because he's innocent.
Well, the other thing that you have with Mr. Mashaney's case too, that was briefly brought up, is you have the victim who actually recanted and said there's testimony in the civil trial of the victim actually later saying, no, this didn't happen. My mom put me up to it and told
But
me.
did the prosecutor dismiss it because of that? Or if we say it was a dismissal, which I'm not sure I can agree it's a dismissal when they amended the charges down. I mean, dismissal is dismissal. Did it have the same case number?
But I think that looking at the statute and what the intent with it, because obviously every case, it's going to have different circumstances, especially when you're dealing with district court, court of appeals, 1507s. I mean, there's a lot that goes into these type of cases. But I think looking at the big things, which is that you had this report that was in his favor that was never submitted. You have the victim, which the victim.
Again, as Justice Stiegel said, that's all going to actual innocence. It's almost like you're skipping the part about causation.
You're just suggesting that the statute doesn't require direct evidence of causation from the mouth of a prosecutor.
Right.
It can be done through circumstantial evidence.
Right.
And by looking at the series of a sequence of events and what the prosecutor did in reaction to the newly discovered evidence, and that can support a reasonable inference of causation.
Right. Looking at the circumstances as the whole, the court can read between the lines and come to that conclusion. But it's very similar to kind of like going back to those DNA tests, where in this case, the only evidence that the state presented in support of Mr. Mashaney's conviction was the victim's testimony. That was the only evidence. If the court goes back and looks at the record from the trial court, we now have a victim who's recanted that, who said, this did not happen. My mom told me to do this. It's not true. And it's very similar to with those DNA cases that have been brought up, is you have the only evidence being shown to not be right, to not be truthful. And I think that the legislature, looking at this case, if the legislature saw, we have a person who the only thing that he was convicted on was the victim's testimony, and we have this victim who now has recanted and said it didn't happen, and we have a report from the only scientific report that was involved in this case at all, because the state certainly didn't present any, the only scientific report that we have in this case at all saying it's impossible that this happened. I think taking those things together, I just think that this is something that the legislature this is what this statute was created for, these type of situations. Mr. Mashaney spent 8 years in prison for a crime that the victim later came out and said did not happen. And he can't get that time back. He went through.
How is this
terrible
different than you have another witness recanting? Every time a witness recants and then it goes back down and they plead to a lesser, or not a lesser, but plead to, why did the prosecutor not dismiss it? I mean, you're talking about circumstantial evidence.
And I think one thing to take into consideration too is Mr. Mashaney was originally sentenced to over 38 years in prison. He did 8, which is a long time, but it's not nearly as long as what he was sentenced to. If the state really believed that he was not innocent, why would they agree to him being let out
So
in
there
8
are-
years as opposed to the 38 that he was sentenced to? So I think that's one thing too that goes to all the things taken into consideration as to what happened between the time that this case was appealed and then it was later, as our argument is, effectively dismissed based on the circumstances of the Alford plea.
Thank you.
I need to move you. I'm sorry, Chief. I got to take a little time here because as I mentioned to Mr. Powell, this causation thing's a whole can of worms. But there's a threshold legal question before we even get to that, which is whether these charges were dismissed. And the district court said that the charges were effectively dismissed. I don't see how that comports with the Sims case. Because Sims says that the dismissal has to mean both terminating the criminal accusation and relieving the defendant of that accusation's criminal liability. Now, we also know that lesser includeds don't work for that. So it's not the charge is dismissed, it's the accusation. And in this case, the accusation is that your client touched an underage girl. Now, the original charges were sex related. The amended charges were not sex related, but it was still ag battery against the underage victim and then endangering a child. You got the same victim, you've got the same touching. I don't see how those facts get you past the requirement of the statute that the charges were dismissed.
My understanding from the reading of Sims is part of that was that the charges that he pled to or were ultimately convicted of were very similar in nature to what his original conviction was. They were along the same lines. If you look at what,
But in your case, it's same victim and it's touching. The only difference is the sexual aspect of the one versus the other.
well, with Mr. Mashaney, the Alford plea consisted of was 2 counts of attempted battery. So you wouldn't even have an actual
Same victim though, and battery. I mean, attempted battery, okay.
So, and I mean, that's a misdemeanor charge, as opposed to a level 1 or 2 felony, that he was originally, convicted of for 1. And for 2, Sims didn't have the other circumstances that were present in this matter. Sims didn't have a ineffective assistance of counsel finding based on evidence that was very favorable to Mr. Sims that was never admitted into evidence. Sims doesn't have the only witness who was presented by the state in the original charges to have come out and recanted his or her testimony. You don't have that with Mr. Sims. He entered not only an Alford plea, but also a plea that allowed him to get out of prison that day, instead of having to sit in prison to await trial. So there's a lot more as far as the surrounding circumstances that are present in Mashaney's matter that weren't present in Mr. Sims. And I would mention too, the district court heard all of this evidence, and the district court specifically made a finding that it made a finding of actual
It's a conclusion of law what the district court did. This effectively dismissed as a conclusion of law.
What I was going to say too is they made the factual finding that Mr. Mashaney was innocent based on what was presented. And I'd also mention too, the state during that trial did not present any evidence whatsoever as to any evidence in support of Mr. Mashaney's conviction or the original charges, or for any other reason for why the charges were not retried.
Would you agree that the Alford conviction is also consistent with the prosecutor not believing the recantation as true.
Can you rephrase that?
Well, if you testify one way,
Uh-huh.
and then you later say, I lied before, I'm telling the truth now, one of those times has to be a lie. If the recantation is true, then the original testimony is a lie.
Okay, I get
The
it.
original testimony is true, the recantation is a lie.
Yeah.
So the Alford conviction is also consistent with the prosecutor not believing the recantation to be true, correct?
Okay, I get what you're asking now. And my response to that would be, so what was presented in the civil court was the daughter actually approached Mr. Mashaney and apologized to him and said, my mom put me up to this. I'm sorry that this happened. The daughter also went to both of Mr. Mashaney's parents, her grandma and her grandpa.
I
and said the
understand
same-
her recantation was repeated several times.
Mhm.
But go back, focus on the prosecutor.
Uh-huh.
Is it consistent with the prosecutor in the criminal case not believing the recantation?
Well, and I don't know what, I mean, based on the circumstances of the recantation, she was older when it happened. So I would argue at a point where she could she could speak for herself instead of just mimicking maybe what an adult told her to. She was only 5 when she testified at this trial when this happened. So when you have a 5-year-old who says one thing, as the child gets older, the child's probably going to be more likely to be able to speak for themselves and not just mimic what a parent's telling them to say.
Okay.
So you have that, and then you also have she repeated that recantation to at least 3 different individuals, including Mr. Mashaney himself, the person that was accused of doing this. She approached him and apologized.
Yes, I
So-
understand. Thank
Okay,
you.
Thanks.
See no other questions?
If there aren't any other questions, I'll step down. Thank you.
Okay, thank you.
May it please the court, I'll be very brief. I want to address what Justice Wall raised about inferences. I don't disagree that you could draw inferences from the record to try to make some findings as to the prosecutor's motive. I certainly think that's possible in these cases. I don't think you have to have necessarily the testimony of the district attorney. But I would respectfully say that in this case, you can't make inferences that the prosecutor thought Mashaney was innocent and that's why they agreed to the amendment. I think the inferences go the other way. And particularly if you know Mark Bennett like I do, that's obviously that's not part of the record, but he's a straight shooter. He didn't try this case originally. Christine Ladner did, but it was Mark Bennett who I think at that time was district attorney. He's the one that agreed to this plea agreement and insisted apparently on a guilty plea or an Alford plea. I think that says a lot about what he may have thought.
Yeah, regardless, there may be conflicting.
Right.
You could maybe draw different inferences from the evidence, but at the end of the day, we don't have any findings, right?
Right.
That's
the fatal flaw right there is we don't have any findings. Mr. Mashaney's counsel, they could have called Mark Bennett to testify as to his reasons. But the bottom line is we don't have any findings to establish one way or another, and I think that's fatal. Seeing nothing. Thank you very much. The court would just, the state would ask that the court reverse the district court and vacate the district court's judgment against the state. Thank you.
Thank you. Thank you to both counsel for your arguments today. The court will take this matter under advisement.